Next up, we have case number 250004, Cassandra Breitenstein and Darren Breitenstein individually and as next friends of SB versus Larry Peterson and Sue Ann Peterson. And it's the court's understanding that appellants are represented by Attorney Grant Gangestad and appellees represented by Attorney Brent Ruther. All right. Anytime you're ready, counsel.
Good afternoon, Your Honors. May it please the court. Counsel. Your Honors, this case is about whether recreational immunity applies to this case at all, not whether some other defense to liability might. The Iowa recreational use statute creates a quid pro quo. In essence, I gift my land for public recreation. In return, the state gifts me immunity from suit. It's a bargain. It's a get out of liability card, or for people who enjoy the show Survivor, it's the immunity idol. And that's earned only by fulfilling the statute's purpose of encouraging public access to private land. If you don't open the land to the public, you don't get the immunity.
And the public policy angle of that, but the legislature has said that public includes non-public land. So what am I to do with that?
So I appreciate that question. I think this really gets kind of to the heart of the interpretation question here. I believe that the language that you're referring to is the definition or the section that says land includes land not open to the general public. And that particular amendment was in 2013 after the Sally versus Stewart case. And in that case, there was a field trip that went to a dairy farm, and it was found that there was not immunity in that case. In that case, the Supreme Court suggested that in order to have the immunity apply, that you needed to be open to the general public. In response, the legislature says it includes land that's not open to the general public to try to get at those situations like a field trip or a hunting party or somewhere where there's not just a general, everybody all the time is welcome. It covers those situations where it's maybe a subsect of the general population.
Plausible that the legislature was trying to preserve Peterson, which the Supreme Court kind of threw the bat signal on but didn't overrule?
So, again, Peterson, we've got some distinguishing characteristics about Peterson. Peterson was a plaintiff who was injured swinging into a property, into a pond. It was a premises liability case. It was one where the landowner had known the public had used the pond for years and years. And the Supreme Court explicitly noted that the pond was frequented by the public. We've got the opposite situation here. I'm going to use his first name, Larry Peterson. We've got several Petersons here. Testified that no members of the public had ever used the property. He admitted that his prior affidavit claiming otherwise was false and a lie. So we have a different factual scenario here. Peterson, public use without permission. Here we have no public use whatsoever. The holding in Peterson was also narrow. It was only as to premises liability as it related to a trespasser. Here we have claims that are in addition to simple premises liability actions. We have general negligence as well alleged against Larry and Sue Ann Peterson. There's a case that came after Peterson, which was Scott versus Wright. And that case stated that that was negligence alleged on a hay rack ride on a property, and the immunity was raised in that case. And they said this was not due to a premises issue. This was an independent, human-caused negligent act. And the court rejected any reading of the statute that would immunize all independent, human-caused negligent acts. They specifically said the public's incentive to enter and enjoy private agricultural land would be greatly diminished if users were subject without recourse to human error as well as natural hazards. So Peterson is distinguishable in that that blanket immunity was provided to trespassers as well as invitees and licensees. They wanted to get around somebody trying to make that distinction. It was also a premises liability case, and there was public use. It was widely known that the property was used publicly. We have many distinguishing factors here. Sally versus Stewart also questioned the breadth of Peterson. It didn't explicitly overrule it. That's something we acknowledge. But it did say that the purpose of the statute is to encourage landowners to make their land available to the public. Extending immunity to land not open to the public fails to promote that goal. And I think that the legislature, even in amending to include that land not open to the general public, still there's an inference there that there must be some level of openness to the public. If it's simply private familial use, that doesn't encourage the purpose of the statute. And I understand that the language is also added to say we broadly and liberally construe this in favor of the landowner to further the purpose of the statute. And if you look at the floor debates from the legislature, they are all talking about how we want to be able to encourage people to come onto my land, cross each other's land, and do those type of things, not simply to use this as a sword to preclude any liability if one time we allow somebody to do a recreational activity and get immunity for all time. That was not the intention of the statute. The intention of the statute, as it has been forever, is to encourage people who otherwise wouldn't be able to use this type of land to come onto other people's land and do those kinds of things. That amendment did not revive that overbreadth of Peterson. You can't read one sentence or one clause not open to the general public, which isn't defined, to overrule the overarching purpose of the statute. I think you got to read those things together.
Position ask us to read that language out of the statute?
No, I don't think so. I think that what we're asking the court to do is find that in order to get the immunity, you have to have that quid pro quo. You have to have availed yourself of the public in order to get the immunity.
Peterson is putting up no trespassing signs and, functionally trying to keep people off his land, right?
That is correct. Again, there has to be some sort of invitation, permission, in order to get the immunity. In that case, it was whether or not it applied to a trespasser. That was the specific question in Peterson. And again, even if you want to read this statute, which we don't agree that that's the case, but even if you want to read it that others includes any other person, even a family member besides the holder of land, that we still also have active negligence claims here. The only thing that the immunity statute would grant immunity for is for premises liability issues, like the court said in Scott versus Wright.
You about that. Did you ask the district court to divvy out your claims in that fashion, by which I mean, yeah, maybe the immunity does apply to premises liability, but I've got my negligence stuff and I want to keep that going?
That was not specifically that was not specifically briefed. I think the understanding from the case law is that this is only applicable to premises liability claims, and the court then said they've got immunity for everything, everything's gone. That's what the summary judgment motion said, and I don't think that the case law allows that all those other active negligence, human negligence type of claims to be cut off.
Guessed for my question. The reason I ask if that was argued below is I'm a little concerned that error is not in front of us, as interesting as it might be.
And I think that our ask of the court to deny summary judgment, I think that it includes all of our claims here. I think that if we are going to ask for immunity to apply, we apply the immunity to the claims that it can apply to.
Rule it applies to some claims but not all the claims. Didn't you need to ask the district court to apply it to some of the claims but not all the claims?
We asked the court to apply it to none of the claims. We asked the district court to apply it because we don't think it applies to the premises liability claims either, because there is no opening of the land to the public. I think, again, the purpose of this statute is openness. And I quickly want to get to one thing here that I think that we could stop at the beginning if we need to. We have generated a genuine issue of material fact here. The issue of material fact is whether or not the public had access whatsoever. Mr. Peterson provided an affidavit that said, from time to time, we allow others to use the property for recreational activities, including ATV use. I asked him about that in his deposition. And I said, do you see that portion of your affidavit? He says, yes, I see it, but it's false. It's a lie. I said, well, what, can you tell me why? He goes, because we don't allow people to do that. We don't allow others to use our property. I'm sorry if I'm out of time here. If I may just briefly finish this.
I'm going to stop you here, but you will have 5 minutes on rebuttal. Thank you, counsel. All right. Mr. Ruther?
Please, the court, counsel. I'm going to start where you left off. The affidavit of Larry Peterson and the record before this court has much more in it than just the affidavit of Larry Peterson saying that that was a false and it was a lie. It is clear, absolutely clear from the record that others, other than the landowner, use this property. He testified about his, well, I mean, the very basis for the claim is that Avery Peterson, the granddaughter, was using the property with Sarah Breitenstein. It is, yes, I mean, I hesitate to say that the affidavit in Mr. Peterson's testimony doesn't matter. It's a trial lawyer's dream. It's a trial lawyer's dream to have somebody on the stand that's he's gonna be able to impeach him with an affidavit. The affidavit doesn't matter here, okay? Regarding this active negligence claim, Judge Buller is exactly right. This was never preserved. And I'll tell you why. For one reason is because our summary judgment motion also had an entire section on the lack of duty. And that was not reached by the court. Had that been reached by the court, I would have appealed it, or he would have appealed it. So they absolutely not this idea, which I don't agree with anyway legally, of premises liability somehow only dismissing a premises liability claim when there's other claims. Scott does not support that. Scott had to do with the owner's liability statute. There is no support in the case law anywhere that says if you have premises liability, if you have recreational use immunity, that all other claims survive other than that. That makes no sense at all.
Before you reach your next point, you could address the court's order where we asked the parties to stake out positions on whether we even have jurisdiction of this appeal. I know you didn't challenge jurisdiction in your brief, but I think you did in response to our statement.
We did file a response, Judge. I believe that, just like I said in the response, I mean, that's a difficult question, but I think it's left up to the court's discretion. I would concede, and I agree, that the rules of appellate procedure will allow the court to convert this to an interlocutory appeal. But on the other hand, just like I said in our response, I think, you know, it was not filed as an interlocutory appeal, and it was not appealed after the dismissal. So I think it is the court's discretion.
This to your client if we were to grant interlocutory review at this point.
Not if you were in our favor. I'm kidding. No, there's not. Yeah, there's not any prejudice. We have our chance on appeal, and you know, that's.
You don't feel like any arguments have been left out from where we could have gotten in this litigation? Okay, thank you.
Am I correct in understanding the record, too, that if we were to say there's no jurisdiction, the case is over at this point, and the time for filing an appeal from final judgment would be long past?
Yes. Now I want to back up and just, the analogy, the idea that the legislature has some quid pro quo, you don't get immunity unless you open up to the public. First of all, that's not what happened in this case. In fact, I'm not even sure what public means, but it certainly is well defined by Justice Mansfield and in the statute in his dissent in Sally, that others, which is the only other word in there that talks about people, the public, others means anyone but the holder. That means others, everybody, including family. Driving up here, I thought to myself, well, you know, let's take this to its extreme. The legislature and the courts over the course of time since 1967 have expanded this statute, expanded it. The purpose of it is to incentivize landowners to open up their land. It isn't to make them. It isn't, and in Peterson, he didn't want those people using it. He thought they'd get hurt. In fact, they did. So it's not to have all this land open for people who wouldn't otherwise get to use it. In fact, a hunting club, I mean, obviously they use recreational land. The legislature has constantly increased the definitions and the idea and the reasons that immunity should be granted to incentivize landowners. In this case, if you read the statute, Larry and Sue Ann Peterson qualify as holders. That's not disputed. It qualifies as land. It's grassland. There's no dispute. It's not disputed as the main holding in Sally, which I don't think applies to this case at all. This is a recreational purpose. It was ATV riding. Everyone involved directly in the incident, Brad and Jennifer Peterson, their daughter Avery, Sarah Breitenstein, qualify as others per the language of 461C31 and the case law, which states all other persons other than the landowner who makes use of the property. And no one argues an exception applies under 461C. And I would know that there's no any more exceptions about who others is or who the public is. Now, if you took the plaintiff's argument to the extreme, if I have a son who's been estranged for 40 years because he murdered his sister, just say, moved to California, came back to Iowa, 41 years later, gets on his motorcycle, goes out onto my dirt track that I've got, recreational land or public, I mean, you know, rural land, and hurts himself because he's my family member, all of a sudden, I don't have immunity from that. That makes no sense. And it can't be the job of this court or any court really to overturn the legislative words in a statute.
Ask you this, in addition to potentially running into the statute, is it your position that we would have to, which of course we can't, overrule Peterson to go where your opponent wants us to?
Yes, you would. I don't think Peterson is distinguishable because if Peterson's distinguishable, then, and you accept the idea from the plaintiffs that it has to be open to the general public at all times, I guess, but then he also talks about hunting clubs and these subsets, then theoretically you would have protection for trespassers or against trespassing and protection for only land that the farmer or the person said, anybody can come on my land and play. Everybody in between, people who are invited by the family, people who are, you know, had the hunting club, the whatever else, there would be no protection for that. That would disincentivize owners, holders in Iowa from opening their land at all. It would all be fenced in. There would be no trespassing signs. The recreational use immunity is to be read broadly in favor of the landowner. So Peterson would have to be overturned, theoretically. And back to Sally, Your Honors. I mean, we don't believe that Sally's applicable at all. It had to do with the only thing they're relying on is dicta from Sally, and the dicta from Sally was highly criticized in a well-written dissent by Justice Mansfield, and immediately, basically overturned as to the main holding and much of the dicta by the legislature itself, and it hasn't changed since then. All the case law, Peterson, and all the legislation supports our position in this case. And if you don't have any further questions, I'm finished.
Thank you, counsel. All right, any rebuttal?
Your Honor, I'm going to start where I left off because I think this argument is important. The granting of summary judgment here is because the court found there was no issue of material fact here. And that is to the access, the public access. We believe there absolutely is an issue of material fact based upon some contradictions in the appellee's position, specifically as it relates to Larry Peterson's deposition testimony and vis-a-vis his affidavit. And I asked him, why you're saying that's a lie. He goes, we don't allow people to do that. We don't allow people to come onto our property. So you have not allowed others to use that property for recreational purposes? This is an exact quote, right. And owning that land, it's your position, it's your land, and you don't allow others to use that land, correct? Answer, right. Question, so it's not open to the public, correct? Answer, correct. I don't think that that is a minimal or non-consequential issue. That is a factual dispute alone. It's not a he said, she said. It's a he said, he said. We have an issue here where he says, I don't allow public onto my property. He's actively repudiating the purpose of the statute. I don't allow people on here. Essentially, don't give me immunity. This is a factual question that should be going to the jury. The jury can hear the issues and determine whether or not to apply this factual immunity to.
Do you agree that's only material, though, if we agree with your interpretation of the statute, that it does matter whether it was open to the public or not? I mean, if we disagree with that, then it can be a big fact dispute, but I don't see how it would be material under the other side's argument, interpretation of the statute, rather.
I appreciate that, Judge Langholz. The legislature's intentions were well-meaning. I think here the language of the statute is not great. I think we can all agree that that's the case. We refer to, in the definitional section, land includes land not open to the general public. That general public is not defined anywhere. And I think that we look at Sally and say, they're talking about a field trip in that case. They're talking about a smaller subsect of the population. You don't have to open it up to every single person all day, but there has to be some level of openness. Otherwise, you read that sentence to overrule the entire purpose of the statute. So I think that we need guidance from the court on what that exactly means. The other thing that we have to determine is in the actual section that provides liability, it uses the word others. And we, again, have to look at this in terms of the statute. What does others mean? They're talking about use by people other than your family. If I let my son ride an ATV on my land one time, I get, in Appellee's position, I get immunity in perpetuity forever, no matter who rides on there. That's not what was intended by this statute. What the intention is to allow other people to access the land. We don't have that here. We don't have that opening up. We don't have that use beyond a familial, private use here. Public means something other than private and familial. And I think that is important.
The jurisdictional question as well.
Absolutely. So we believe this is a final order. The district court's order explicitly dismissed all claims, as we've talked about, against Larry and Sue Ann Peterson, assessed the costs of the plaintiffs, leaves nothing further to be decided by the court as it relates to Larry and Sue Ann. As to them, this case was over. Appellees have some case law that talks about, the severability and the comparative fault nature of the case. Well, we've got immunity here. We're not comparing fault. Larry and Sue Ann aren't getting a line on the jury verdict. As to them, this was over. Now, I would like to point the court to the new rule 6.101, sub 1, sub D, and it says, "In order disposing of some but not all of the parties or issues in an action may be appealed within the time for appealing from the judgment that finally disposes the case." It says may. So what does may mean? It means there may also be another position that we could appeal as of right from the final decision of the Larry and Sue Ann case. So we believe that it was appropriate there. However, the courts also acknowledge that sometimes determining when a final judgment happens is difficult, and I believe that taking this case on an interlocutory basis is also appropriate.
Thank you, counsel. Thank you both for your briefing as well as for your arguments here this afternoon. We will take this matter under advisement and we will issue a ruling as soon as we are able.